Adopted in 2022, the Digital Services Act is one of the European Union's landmark regulations in the digital sphere. The DSA protects Internet users' fundamental rights and gives them greater control and more choice when they navigate digital services. What is the role of the EU courts in enforcing the Digital Services Act? With us today is Saulius Lukas Kalėda, a judge and the President of Chamber of the General Court. Judge Kalėda, thank you for being with us today.
Sveiki, ačiū Jums už kvietimą ir galimybę pasidalinti įžvalgomis šią svarbę ir aktualią temą.
What are the main objectives of the Digital Services Act and why is it important for EU citizens?
We live in a dynamically changing world anchored in new technologies, which trigger many challenges for our society. The new technologies also have an impact on the exercise of our fundamental rights, which in turn calls for new legal approaches. The Digital Services Act is a central element of the EU's recent legislation in the digital sector. In fact, it pursues a twofold objective. Looking from the company's perspective, it lays down a single set of modern internet rules, which replace potentially 27 national regimes, allowing the companies to operate more easily throughout the EU's internal market. This objective is of great importance because the services that are regulated by the DSA, such as social networks, online marketplaces, online search engines, are crucial for the economy and also for our everyday activities. Looking from the internet user's perspective, the DSA seeks to enhance the protection of fundamental rights, such as freedom of expression, privacy, the rights of the child, or the rights of consumers. This consideration reflects the Court of Justice's case law, which shows that the internet has become a crucial space for the exercise of fundamental rights. This objective is achieved by imposing due diligence obligations on providers of digital services, which have to manage online content in a transparent and responsible way. They also have to give more choice to internet users and to give them a greater degree of control over the tools that are used to moderate content and recommend it to users. The Digital Services Act also confers rights on internet users, such as the right to flag illegal information, the right to receive a reasoned explanation whether content is removed or their account is blocked, and the right to contest providers' decisions.
Are there any provisions for very large services, such as Google Search, YouTube, or Facebook?
Well, the DSA follows a gradual approach in order to protect innovation, which means that the smaller companies face lighter requirements, and the most stringent regime applies to a handful of very large online platforms and search engines, which have over 45 million users in the EU. There are currently 26 such services which are designated by the European Commission and are supervised by the Commission under the judicial oversight by the EU courts. They have the obligation to conduct regular risks assessments, compulsory audits, take risk mitigation measures, for example, in relation to the risks stemming from the use of illegal content, the risks for vulnerable users, especially for children, and the risks for democratic and electoral processes.
The General Court has already delivered several judgments on the Digital Services Act. What are the main takeaways?
The DSA is an innovative piece of legislation, which means that its application will very much depend on the interpretation given by the courts, both the EU courts and the national courts. The Court of Justice has its role as the ultimate interpreter of the EU law, and in fact, the national courts have already submitted first preliminary questions on the interpretation of the DSA to the court. As for the General Court, it is at the forefront of judicial control of the Commission's activities concerning very large providers. Indeed, the General Court has already delivered several DSA rulings, including two important judgments confirming the designation of Amazon and Zalando as very large online platforms. In those judgments, the General Court rejected their arguments that the provisions concerning very large providers are disproportionate and infringe the freedom to conduct a business. Both companies have lodged appeals, so the final say on these issues will be with the Court of Justice. There are other DSA cases which are still pending before the General Court, so these are just the first steps in the application of this important act.
Thank you, Judge Kalėda, for this explanation on the role of the General Court in the application of the DSA.
Ačiū Jums už dėmesį.
See you in the next episode of Open.